they get overwhelmed with debt. It just piles up. They get the letters, they get the harassing phone calls, but they need to know that they have rights and you can help them protect themselves.
Yeah, they have rights. They have protections afforded by state law, by federal law. There's all kinds of things. Creditors will work with them, even though sometimes people believe that the creditors aren't going to help. And in a lot of cases, they will. And then when the creditors get over aggressive or when the debt becomes overburdensome, that's where we come in to give them a little bit of relief.
Yeah, they come in and get aggressive. They're calling. They can't call between certain hours, right? Like after 9.
They can't call. I want to say it's before 8 or 9 in the morning. They can't call after 8 or 9 at night.
Yep.
They can't call multiple times. They can't threaten. They can't pretend to be police. They can't threaten arrest. They can call family members. They can call friends. They can call neighbors, but they can't tell them why they're calling. All they would do is say, "I'm calling to locate Mr. or Mrs. So-and-so." They can't say we're calling because they haven't paid us.
Wow, that's a new one.
They can't say, they can't use derogatory terms. They can't say deadbeat. They can't say that kind of stuff.
Yeah.
So yeah, and I've seen almost all of those situations happen from time to time.
Wow, I bet you have some good stories. Any recent success stories or anything that you could mention that would be topical?
I'm working on a case right now. My client is on a fixed income. I think she makes like $800 a month in fixed income. She turned in her car, and I don't know if I should say the dealership, but she turned in her car.
Yeah.
And they put her in a brand new car that she's wanted her to make $500 a month in payments.
Huh.
Well, math should tell you if you're bringing home $800 and you're needing to pay $500 for your car, that doesn't leave you much to live on.
Yeah.
When she couldn't make the first payment, they repossessed the car and made fun of her while they were doing it. So,
whoa.
Yeah, so we're going after them to get the debt released, see if we can get the old car back, which may not be possible, but we're going to see. Get the debt eliminated, get the old car back, get the credit cleaned up, get the liability eliminated, and I think we're going to be able to do it. We're on the verge of filing a lawsuit, but maybe I can resolve it without that.
Wow. Yeah, that's sad, man, when they rub it in with the extra,
Yeah, they were laughing at her. You knew what you were doing. You knew what kind of payments. We're going to call the police. All the typical stuff that creditors do.
Wow. Yeah, so Crushing Debt podcast, check him out. That's Shawn Yesner, attorney Shawn Yesner. Let's switch gears. So we talk about debt. You can help people with bankruptcies and those scenarios. But since we have Donna in studio today, I wanted to focus a little bit more on some of the landlord-tenant type laws, different situations in the real estate space. What do you see with the tenants when you're looking at a landlord-tenant playing out? What's some of the common misconceptions that people have?
Yeah, I think the biggest thing when you're talking to landlords, a lot of them don't understand, and Donna can probably weigh in on this, but what they'll do is they'll say, we need our tenant out, we're on a month-to-month obligation, we need to get the tenant out. So today is whatever date, call it the 18th.
Yeah.
And I'm going to give 15 days notice. You got to be out 15 days from the 18th. Well, that's not how it works.
Right.
You got to give 15 days notice prior to the end of the month if they're on a month-to-month occupancy. And so, someone who says you got to be out by May 18, well, really what we're saying is you got until the end of June to be out, because that would be 15 days prior to the end of the next month.
Right.
If you're at May 10, you can say be out by May 31. You're more than 15 days prior to the end of May. Mm-hmm. So I think that's the biggest misconception that I see from landlords is I'm just going to give them 15 days to get out because Florida statute says 15 days, and it doesn't work that way.
Yeah.
It's 15 days prior to the end of the month. The tenants who are on a month-to-month lease can do the exact same thing. They're tenants, so they can call their landlord and they can say, love living here, but 15 days from now, assuming I'm 15 days prior to the end of the month, I'm leaving.
Right.
And they can move out just as well. So I think calculating those time periods is an issue. The other big issue that I see is the tenant, the landlord that goes to evict, and the tenant says, you can't evict me because there was some problem with my property and you, landlord, didn't fix it. Well, that's not a defense to an eviction case. There is some case law that if you provide your landlord with proper notice of something going wrong in the house, that you can then cancel your lease and get out. But if you don't send the landlord the proper notices and you just stop paying rent, I'm going to stop paying rent so I get my landlord's attention. Yeah, you'll get the landlord's attention, just not in the way you want.
Yeah, you'll get a lot of other attention.
You'll get a 3-day notice letter attention, and that's not what you want.